Good evening, everyone, and welcome to the JSW Future of Law workshop for this month. This month, we have with us uh, Madhavi Singh, who is the Deputy Director of the Thurman Arnold Project and a resident fellow at the Information Society Project at Yale. Um, we hold these workshops every year and every month, where we invite scholars from around the world to talk about some of their ongoing work regarding the themes of future of law and how law is changing with the advent of technology. We're also grateful to have Professor Vikas Kathuria with us, who's going to act as a discussant for this workshop. So today we'll follow a format where we'll have Madhavi present her work for around 20 minutes. We'll follow up with discussion comments by Professor Vikas for around 15 minutes, and then we'll open it up for Q&A. So Madhavi, before I hand it over to you, I just wanted to give a short introduction. Madhavi Singh is a Deputy Director of the Thurman Arnold Project and a resident fellow at the Information Society Project at Yale. Her professional experience includes working as an antitrust associate, research fellow, and visiting lecturer in India, Singapore, and the US. She was an antitrust associate with the leading Indian law firm Shardul Amarchand Mangal Das, where she worked both on enforcement cases and mergers and acquisitions. Before coming to Yale, she was a researcher at NUS and a visiting lecturer at NLS and NUJS. She's also an alumnus of this institution. So welcome back, Madhavi, and over to you.
Thank you so much for the introduction, Rahul, and thank you so much for inviting me to present my work in progress paper. It's always good to be back to National Law School and be a part of this community, even if it is virtually. So let me see if I can share my screen. I prepared some slides. I will try to run through them. Oh, okay. I don't use this very often, Microsoft Teams, so it will take me. Okay, I am unable to share my slides. Well, in that case, I will present without them.
Let me see if I can give you presenter access. I think it should be possible. Let's see. You should have access already because you're a panelist. Could you try now?
Sorry about that. I think it asked me to reopen and. Well, never mind. I'll present without. Am I audible?
Yeah, you are.
It's fine.
Sure?
I can present
sure.
without. That's no issue.
Sure, go ahead.
So, right. So a little bit about myself and my research. I look at the role of antitrust law in regulating digital platforms and emerging technologies like AI. I think a lot of the important work that happened over the last decade or so in antitrust law was basically formulating how big tech falls within the framework of existing antitrust laws. So a lot of people could feel the power of big tech, but it was far more difficult to articulate the kind of monopoly power that big tech had within existing frameworks of antitrust law. So that's the important work that happened in antitrust scholarship in the last 10 years or so. I think that now the important work that needs to happen is to explain similarly the power of big tech or AI companies as they emerge in these new markets. So that's where my work is situated. I try to understand how big tech monopolies could extend their power into new AI-related markets, or how new AI monopolies could emerge and the role of antitrust law in preventing or regulating these new AI monopolies. So this work that I'm going to share today is also situated in that intersection. Specifically, it looks at the role of Google in scraping Google's monopoly power in scraping publisher data and its subsequent AI integration in search. So it all started with the release of chatbot of the release of ChatGPT, and the release of ChatGPT prompted Google to declare code red internally, and it started aggressively releasing a lot of AI features in search, such as AI overviews, AI mode, etc. It was a pretty existential moment for Google itself because it realized that it risked losing the status of being the gateway to the internet to another company. So I think that the moment that Google's declaration of code red internally was very similar or historically analogous to Microsoft's internet tidal wave memo. So for those who might not know about this, in the 1990s, when the internet started catching up, started becoming popular, Microsoft similarly faced a very existential threat from the internet. And that wasn't because it was facing competition in operating system, which was where Microsoft was the dominant player, but because it was afraid that it would lose its gatekeeper status to browsers. And most people, instead of using apps domestically on their laptops or on their PCs, would move and would start doing all of the same functions on browsers instead. So it was afraid of losing that gatekeeper position. Against that backdrop, Bill Gates wrote this internet tidal wave memo, which came out during the Microsoft antitrust trial, talking about how Microsoft must ensure that it doesn't lose this gatekeeper position and must ensure that it moves to the next generation of technology. So Google's declaration of code red is very similar. It realizes that a lot of people now might move from searching directly on Google to using chatbots for the same purpose. And therefore, it declared code red and started introducing AI overviews and AI mode and a lot of other features into its search to ensure that it doesn't lose that gatekeeper position. So what's the problem, right? So the problem is that when Google does this, it reneges on the original bargain on which the internet is based. So the original bargain of the internet was that Google allowed publishers publishers allowed Google to scrape their websites for free in exchange for referral traffic. So Google used publisher data to create its search index, and in return, publishers, by being on the search index, it helped with their discovery. It helped them get referral traffic, and they converted that referral traffic into ad revenue or subscription revenue. And initially, that bargain worked really well because Google could develop its search index, which worked very well for people. It helped consumers discover information. It also worked well for publishers and content creator because it helped a lot of small publishers and small content creators be discovered through Google. The problem started when Google became the dominant search engine. Then its bargaining power increased and the relationship started getting skewed, and it started eating publishers' lunch. In many ways, this is not really a new story because publishers have been complaining about this for a really long time. And so, for example, a lot of, sorry. So for a very long time, publishers have been complaining about this. Some people might recall that publishers complained when Google News started, and Google started using publisher excerpts in news preview without taking explicit consent from publishers. Similarly, there were other features such as knowledge panels, which is this panel that appears on the top right-hand side of the search of the search results page, and also question and answers features on Google search, such as people also ask, which tells you a lot of related questions that you might be interested in. All of these were things that publishers started having a problem with because they realized that these features in search resulted in an increase in zero-click searches. Many user queries were satisfied without clicking on the links, which meant that publishers didn't get any of the ad revenue that Google made on those searches. So the new bargain of the internet has now become that Google is using publisher data not just for creating its search index, but also for a lot of additional purposes. And publishers are getting less out of that bargain because referral traffic has decreased, and therefore their ad and subscription revenue has also decreased. So how is Google extracting more in return for less? What is this extracting more? So there are a few ways in which Google is using publisher data, which wasn't part of the original bargain. So one is the use of publisher data in training its data sets. There is unfortunately very little information available about what exactly constitutes training data sets for most AI models, including Google's AI models. But we do know that Google uses publicly available data, which is all publisher content that is available on the internet. And it has also been using data from some of its verticals, such as YouTube. This wasn't really known to publishers for a very long time, but it came out afterwards. Google did, we don't really know whether it uses data from its other verticals, such as Maps or Gmail. But there have been some scholars who have speculated that Google has been changing its terms and conditions and its policy to ensure that it can use data from its verticals subsequently. But the long and short of it is that Google is using a lot of its data, and especially having access to the data of its verticals means that it is very well positioned. Most of the publicly available data has already gone into AI models. So having access to this proprietary data from verticals does give Google an advantage. But the use of their data in AI training data sets was not something that publishers had originally agreed to. So this is an additional use of publisher data. The second additional use of publisher data is its use in a process called grounding or retrieval augmented generation, which is basically this mechanism by which AI models draw on fresh information that was not part of the original training data set. So anytime you look for something that's in the news, like when you ask about a sports team, your AI model gives you not just dated information, but also new news, the new wins of that team, new members who joined that team, etc. This information was not part of the original training data set. So what the AI model does is that it goes out and retrains on targeted specific information. Once again, it relies primarily on publisher data for this retraining or grounding. Grounding is really important because it is an important licensing opportunity for publishers. It gives publishers a chance to once again intercept the AI companies, and it also gives them more leveraging power because this is very important information. AI models will be of very limited use if they do not have up-to-date information. So some startups have suggested that there could be third-party marketplaces that monetize AI companies visiting publishers on a per query basis. So it's a very important use of publisher data that is currently not being monetized because Google has a dominant position in search. And finally, Google has not been attributing its use of publisher content. So this is basically like some people call it the 3 C's, right? The absence of consent, credit, and compensation. So publishers are being denied consent, they are being denied compensation, and of course, all of these users are without their consent. So the improper attribution problem is that Google claims that even though publisher traffic through original avenues might decrease, publisher now have an additional access through which their sources might be clicked on, which is AI overviews. So Google started using publisher links in AI overviews itself, and it claims that that's a new source of traffic. However, there is a lot of misattribution problem in AI overviews. So a lot of time, publisher links are not included in AI overviews or in AI mode. Other times, there are broken URLs or they are misattributed to a different source. And a lot of studies have shown that the increase in referral traffic from AI overviews itself does not exceed the loss in referral traffic that has happened because of the increase in zero-click searches. So that's where we are at, that Google is using publisher data for all of these additional purposes which were not part of the original bargain, and it is doing that in exchange for less. So what is this in exchange for less? There has been a clear reduction in traffic and revenue. There have been a lot of studies. Digital Content Next released a study in August 2025 which showed that there had been a median 10% year-over-year decline. There have been other studies which show that click-through rates have fallen by as much as 50%. The loss in referral traffic, as I said, has not been compensated by the increased referrals through AI overviews or chatbots themselves. The frequency at which AI overviews is displayed in search results has also been increasing. So AI overviews does not appear in response to every search that you do, but the frequency at which AI overviews has been appearing has been increasing over time. Additionally, the space that is attributed to AI overviews on the search results page has also been increasing, which is really problematic because now almost half the screen is taken up by AI overviews. And if you're using search on your phone, then most of the screen is taken up by AI overviews. And that obviously means that publishers' margins are being squeezed, which has resulted in layoffs of writers, editors, journalists, some small publishers also exiting the market. And it also deprives publishers of an additional revenue stream, which is use of their data for training data sets. It's also important to note that while other AI companies have been entering into licensing deals with publishers, Google hasn't. So with the notable exception of Reddit, Google doesn't really feel the pressure to enter into licensing deals because it already has this crawler infrastructure, which it uses for its for training its AI models. So I think what this does is essentially it marks a shift in the relationship between Google and publishers. Google earlier used to be the distributor. It used to take you to the publishers, but now it is the publisher. It has become the publisher itself. It is the end destination. A lot of people get their questions answered on Google itself without clicking on links, which would have been fine. You might think that this is just evolution. This is new technology replacing old. But the problem is Google is trying to be a publisher without substituting the journalistic function that publishers do, which is hire editors and journalists and writers to actually do the work. It is just mooching off of all the work that publishers have done so far, and it is just reproducing that without actually creating the institution and the resources needed to actually do journalistic work or the work of publishers. There are also other harms. So apart from the harms on publishers, there are also harms on consumers, which is a constituency that antitrust law traditionally has been very concerned with, because right now we still have access to many publishers, but as publishers continue to get squeezed by Google, a lot of them will exit the market or the quality of their content will deteriorate. So it affects both the quantity and the quality of content that consumers have access to. Additionally, it will also affect AI models themselves. So even if you are one of the few people who really likes AI overviews and think that you get all your answers from AI overviews, the quality of AI overviews and AI mode will also deteriorate as original publisher content decreases. Because right now we have a lot of training data that is available, but publicly available training data, like I said, is almost already depleted or will soon deplete. And as publishers exit, there is new original content to train on. That means that this is a phenomenon which was described in a paper in the Nature called model collapse or AI cannibalism. So if AI models are trained on synthetically generated data instead of original publisher data, their quality deteriorates. So their rates of hallucination and their rates of producing gibberish increases. So eventually, we will reach a point where AI overviews or the AI model themselves will plateau, or even worse, their quality will deteriorate. So there are plenty of harms to consumers. Apart from that, of course, we're not just talking about another product market. We're talking about the media ecosystem, which is the fourth pillar of democracy. So it will have lessening of competition in the media ecosystem has dire consequences for the public sphere. So there are plenty of harms. Now, do publishers have the option to opt out? So in 2023, Google introduced something called Google Extended, which was an instruction that publishers could add to their robots.txt file. So robots.txt is the this file that publishers can have on their website, which is a set of instructions that you can give to bots or crawlers about what they may or may not crawl on the website. In 2023, Google introduced something called Google Extended, through which it ostensibly gave publishers the power to tell Google's crawlers not to crawl the publisher content for AI training related purposes. So it was an opt-out of Google's AI training related functions. However, so even when that happened, there was this very interesting study that was released by Reuters Institute at Oxford, which showed that even when there was an opt-out, publishers were afraid of opting out. So while 79% of top US news organizations opted out of OpenAI's AI crawlers, only 36% opted out of Google's AI crawlers. If you're interested in the numbers in India, were 60% of news publishers in India opted out of OpenAI's AI crawlers, but only 20% opted out of Google's AI crawlers. And the reason that the report cited was that publishers were more hesitant to block Google's AI crawlers because they were afraid how it would affect their search ranking. And this is after Google's assurances that it wouldn't do that. But Google's power is so much that even the threat that it could even minutely affect publishers' search ranking resulted in most publishers not blocking Google's AI crawlers. And so this is happening on Google, but with YouTube, their relationship is even more constrained because publishers cannot opt out of use of Google's AI training models at all. So while YouTube publishers can opt out of their data being used by OpenAI, Perplexity, etc., there is no similar option for opting out of use by Google's AI training models. But so for some time, it seemed like there was an opt-out and publishers weren't really using it because they were afraid that Google would remove them from search index entirely. But as it turned out, that Google had not been honoring that opt-out at all. So even for the few publishers who opted out of Google's AI crawlers, that was not something that Google honored. So this came out interestingly during the Google and US antitrust remedies trial. There was this interesting testimony which showed that there's this interesting internal document which showed that Google had been using even opted out publisher content for training its AI models, specifically for use in AI overviews and AI mode. And the way it justified that is through a technical distinction. It said that the opt-out was applicable only for DeepMind, which is Google's AI lab related products, but it didn't apply to the search organization related products, and AI overview, AI mode are the search organization related products. So that's the technical distinction it made, but obviously publishers were not aware of that technical distinction. And the end result was that even when publishers opted out, most of their data ended up being used by AI for training related purposes. Another interesting document which came out in the Google antitrust trials was this internal document that showed that Google knew that it could give publishers a lot of control. It specifically considered 6 different kinds of controls that could be given to publishers, but it went with the most conservative one. It showed that most of these controls would have been technically feasible, but instead it decided to give publishers no way to opt out unless they also wanted to opt out of being in the search index. So it went with the most conservative option, which is no real choice at all, because if a publishers have to be on the search index in order to be discovered. So the choice that you either be on search index at all, in which case you also have to give your data for AI training, or you can choose just not to be on search index. That's not a real choice. That, as one publisher put it, that is a choice between a slow death and an immediate one. So there was no real opt-out that was provided to publishers. Now, what does all of this storytelling mean in legal context, right? So I think that one way to think about this is Google's monopoly power. Google has been in most jurisdictions, it has been established through a string of competition cases that Google has monopoly power in search, which should have been obvious to us, but in any case, it has now been established in most jurisdictions, including EU, US, and also India. That Google has a monopoly in general search services. I think that the Google's power over publishers is an extension of its monopoly power in search. Specifically, it is the monopoly buyer of publisher data. For those who don't know, monopsony is basically when a buyer has monopoly. So monopoly is when there's a dominant seller. Monopsony is when there is a dominant buyer. Common examples which include things like gig workers, etc. When there is a monopoly buyer of labor, there are also monopoly buyers commonly in agriculture or pharmaceutical settings when there are, say, multiple sugarcane producers, but just one sugarcane factory in that area. So there's a monopoly buyer in that geographic market. So Google here, because it is the dominant search engine, by virtue of that, it is also the dominant buyer of publisher data, because publisher content is the most critical content, a critical input used to build search index. Google is the monopolist buyer of that input precisely because it is a monopolist supplier of search. So what Google is doing here is basically abuse of monopsony power, which is a violation of Section 2 of the Sherman Act. It's also a violation of Section 4 of the Indian Competition Act, which relates to abuse of dominant position. The elements of that offense is possession of monopsony power, which, like I said, has been established in most jurisdictions. And the second element of the offense is the existence of exclusionary conduct. Now, the exclusionary conduct in a monopsony context takes the form of imposing lower than competitive prices. So a monopoly seller imposes higher than competitive prices or imposes exploitative terms, whereas a monopsony buyer, because you're the dominant buyer, you can impose low prices. So a monopolist buyer imposes lower than competitive prices or exploitative terms. Now, the lower than competitive prices in this case basically is publishers providing their data for all these additional uses for free, where they could have charged something for these additional uses of data for licensing, etc. It also takes the form of a reduction in referral traffic, a reduction in ad revenue, reduction in subscription revenue, etc. The exploitative terms that Google as a monopsony is imposing is the absence of an opt-out, the fact that publishers have no control over how their data is used, they do not get credit for it, etc. The anti-competitive effects, which is something else that usually in an abuse case or even in a Section 2 monopsonization case, is that there's plenty of evidence of harm to publishers and consumers. Like I pointed out, there are several studies that show that there has been a reduction in referral traffic and also reduction in revenue for publishers that can be attributed to the introduction of AI overviews and AI mode in search. So I think that this is an easy case to bring because most jurisdictions have proved that Google has monopoly in search, and this is an abuse of its existing monopoly power in search. So what kind of remedy could be imposed? Now, this is a work in progress, and I'm still trying to think about the remedy. But one reason why I would like someone to bring this type of case is because the remedy in such a case could potentially be very simple. And recently, Antitrust has had very bad experience with imposing or not imposing remedies. And there's just a general sense of disillusionment that even when a case is hard won, there are very few remedies that are used. And courts have been reluctant, especially to prescribe structural remedies. But I think even a simple injunction in this case could go a long way. So if we just tell Google that you cannot use publisher data for all these additional purposes without their consent, then it should go a long way. But I must admit that the remedy part of it is still a work in progress, and I have to figure out whether this remedy is enough specifically for the small publishers. So happy to hear your thoughts or feedback on the remedy bit or any other parts of the paper. But thank you so much for the opportunity to present.
Thanks, Madhavi. Really fascinating stuff. Before I hand over to Professor Kathuria for his comments, let me just give a short introduction. Professor Kathuria is a professor at BML Munjal School of Law and heads the Center on Law, Regulation and Technology. Professor Kathuria has previously worked with the Competition Commission of India and has held academic positions at the Jindal Global Law School and Bennett University. His research papers have been featured in international peer-reviewed journals, including the Journal of Antitrust Enforcement, Journal of European Competition Law and Practice, European Competition Journal, World Competition, Computer Law and Security Review, and Law and Development Review. Professor Kathuria, please go ahead.
Yeah, hi. Thank you. Thank you so much, Paul. Thank you so much for Madhavi for presenting this very interesting paper. So, look, I'll be I'll try to look. It can be turned into a very beautiful paper, and I'm glad that you have chosen this topic. In fact, like you spoke about this skewed rent distribution between like along the supply chain in the internet. Now, this is something which has manifested in different forms. If you look at the price parity clauses, like, the hotel cases, etc. So basically, you provide the platform and you host businesses, and then you dictate the terms to the businesses, your business partners. And this has been possible in the specific technological and economic context of digital markets because they tend to become gatekeepers, right? They tend to become monopsonist in your case. But even if they're not the dominant position holder, they can certainly be gatekeepers, and hence they have the power to dictate the terms of engagement in digital market. The case that you have chosen is very important. Like it's very important. Let's start with the beginning. So you say that internet has seen like three waves. The first wave was like you come up with this uh, indexing of pages. You go through the publisher's content, etc. You use it to rank the page, and this is how it features. So it basically the content makes you develop your own product, which is the Google search. The second thing is that it is kind of a symbiotic relationship. Let's get into the monopsony business later. It's a symbiotic relationship because even publishers benefit out of this relationship because it's sort of a gateway into their web pages, and Google search became very strong, so it picks up these small excerpts and directs the reader to the potential paper, to the potential page. You say that now we are into the third wave in the sense that Google has become very powerful and it is using the publisher's content to train its AI generative AI agent, which is sort of cutting into the market share of publishers, right? Previously, people would visit the publisher's web pages. Now they are getting the entire content on the generative AI summary, which is sort of good enough, and they do not proceed ahead. This is the third part. Let me take you back to the second wave, Madhavi. Back in 2019, like, I did a paper with an IP expert. Now, that paper's title was a Google snippet, an IP wrong that competition law cannot fix. I'll be happy to share this paper. Like, it went, it's still like, at that time I was a senior researcher at Max Planck. So it featured as a Max Planck research paper. We did not push it ahead anyway. But let me tell you a little bit of story about it. So you have brought us to the third wave, but the second wave itself faced a lot of problem. The problem was that when Google came up with Google News kind of product, it was showing snippets. When it was showing snippets from the publishers, the theory, like the theory of harm, or at least the argument that was advanced by the publishers was that, like, look, now nobody's coming to our pages. So that symbiotic relationship has somewhat skewed now. Now we are not benefiting out of it. They formed themselves into a group. They raised questions on Google's business model and its implication for democracy and all for the political process, etc., etc. The big obvious things which we can think about. The response, the response of the Germans initially and later on the European Union was, you know what, to tweak the copyright. Copyright, of course, is like based upon incentivization. It gives sort of like an illegal exclusivity. The idea is that, the author monetizes. Okay. So copyright per se does not have a redistribution feature. By implication, it might have, like if Madhavi Singh has written something, she puts her name to it and she has the right to monetize upon it. But per se, it does not have the redistribution feature. The feature that it has is like, this exclusivity, the incentive that you gain out of it. Now, what they did that they extend, because there is a fair use exception in copyright that to a certain extent you can use the snippets. But the funny thing is that no, they came, their heart was at the right place. They wanted to benefit these publishers. They came up with the neighboring rights. Like they created neighboring rights in snippets. Now, this is a property right which they created. Now, if you look at the creation of this property right, this in itself is questionable because in law and econ literature, you create property right only when there is a free riding problem. Okay, when you are free riding on my product. Now, this is something which again can be questionable because we were always in a symbiotic relationship. Now, one can argue that this was skewed in the favor of Google, but that is something which can be questioned, and people have really poked holes into it. I'll share the paper with you. You can look at the footnotes. Christoph Greger, he wrote extensively on it. He said that, look, it's not the authors, it's the publishers who would eventually benefit out of it. And if you create such kind of a right, that means like a blog piece by Vikas Kathuria would be at par with a beautiful paper by Madhavi Singh, now which she has taken 3 or 4 months to develop. Now, this is also something which does not make sense. Now, this was very much criticized. I am not going to get into the intellectual property because you and I, we both are not IP people. Perhaps you are, but I am not. That's why I chose to co-author this paper. However, the more important thing, Madhavi, is that the legislature created property rights. Okay, that this snippet is your property. And now when the property right happened, Google said that, hello, good, beautiful, very nice. I'm not using it. I'm not using it altogether. So Madhvi as a publisher would perhaps rank in the search, but there would be only the title, nothing, no snippet. And so who would lose out? Basically Madhvi. Now, Madhvi, what you do as a publisher, you pull me to the competition authority in Germany and in France. Then you say that, look, Google is a dominant buyer, monopoly problem, which you were discussing here. Back in 2015, it said that, look, Bundeskartellamt, it's a dominant buyer, but it is not taking my product. It is not taking my property, and I have the property right. Mind it, in your case, the property right is not clear because the copyright is still struggling. The latest Munich order perhaps can help you, but the IP community is very much divided into it. However, we'll come to it. I'll revisit that part. I'm just completing my story. Now, the Bundeskartellamt said that, look, very good, you have the property right, which is questionable, but we are a competition agency. We are not like, IP regulator. We are not going to get you. We are not a civil court. In Germany, it's a civil court that looks into the propriety of IP or the otherwise. It said we are not going to get into it. But the thing is that it is a prohibitory right. A property right is a property right. Like, say, for example, you have property over someone, you can stop me from accessing it, but you cannot force me to buy it. You look at the difference of Bundeskartellamt. Bundeskartellamt says that, yes, you have a property right. It is exclusive in nature. It's prohibitory, but it is not permissive in the sense that it does not push me to buy it. So Google does not have any reason to trade with you. It's not the refusal to supply case. It's a refusal to buy case. I said, no, I don't want to buy your content. More so, it said that Google is doing to comply with the copyright exception, the the naming rights that you have created, because the scope is not very much clear how many words should be there, how many should not be there. It is saying that I would rather not use except at all. And then there was unfairness, discriminatory, etc., all these arguments. The Bundeskartellamt looked into it, and it said that none of these can be justified in the facts. But the most important aspect is like refusal to buy is not something which would come under the ex post competition law. Anyway, the French, however, they are the French, right? Of course, the state has a bigger role, like, the welfare state, redistribution, etc. The French Competition Authority took a contrary stance to the Bundeskartellamt. Our analysis, like we had to translate all the decisions, etc. Our analysis suggested that the French were completely sort of like, fascinated by the objective of the copyright law, the creation of the neighboring right, that they are trying to save the democracy and they are trying to save the publisher, etc. On substance, we criticize that, the competition law regime as we know it does not support this stance. Anyway, so these are the two things. And our suggestion was that no, it was an IP wrong. IP rights should never have been granted on copyright because the purpose of IP right is not redistribution. It comes to the realm of competition law. And we suggested that the Bundeskartellamt did the right thing. It was not the French authority which did the right thing. Why we did that? Because, you might just accuse that we were analytically purist. But that's what we do. Like, every legal tool has a specific purpose. Now, this has been an allegation against competition law that it is now being turned into a Swiss knife. It is doing so many things at the same time. In this case, like the Facebook decision of the Germans, like Bundeskartellamt, and subsequently the CJEU upheld it. Perhaps theoretically that could be justified, but even theoretically, this stance was not justified. So we did not complete the circuit in the sense that we did not advance the case further. But you know what the Australians did? Instead of trying to do the justice to the intellectual property framework or the competition law framework, they created a bargaining code, a new animal altogether. It said that, look, Google, you need to sit down with publishers. I'm not talking about justifications to the competition or intellectual property. You have to sit down with the publishers and you have to negotiate with them. And Australia is a too big a market for them to say goodbye to. They did not. An Australian way, in our view, is a much, much better way. Now I come to your part, which is a third way, and you are extremely right. However, you do point out, and there are justification. I'm glad that you have pointed out the Pew Research survey and you have given some data as well. However, it's still not certain that that generative AI overviews are eating into to me, yes, it would happen. It's just a matter of time. But we need to say it's a scientific piece. So it's still not clear whether it's in the same relevant market in the sense that it's going to eat into the search as we knew it or as we know it. Because Justice Mehta, he said that it would eventually be the case, like it is under threat from generative AI. However, the UK DMCC Google search decision, like which came out last month, is not counting it's not treating the Google, what do you call it, this overview as part of Google search. It is considering it as a different thing altogether. So still like the authorities are divided, but your state data is strong. But if you just refer to these two things and then you do decisions and then you talk about the data, it will be all the more scientific, your part. Okay, now I have the entry. I know the fear is there. I have created a hook for my reader so that she finds it interesting and goes ahead. Now my problem is the same that was in the second case. I'm using your content to train my generative AI agent. How can you stop it? Do you have a property right on it? Now that is something very, very, like the entire world is confused about it. The world is divided into two parts. Those who say that, it is covered by this copyright exception, the T-text and data mining exception. They say it's totally fine because it is not transformative, etc. Right? And those who say that, no, it can be. They are taking the stance that the Munich court has taken. Now, but then you need to discuss this thing. I know you are not an IP person, but perhaps if you can just show that, the problem that in the IP world is, it's split into two and nobody's coming to your aid publishers. Then I will see like, what if, uh, sorry, a property right is given. If, however, a property right is given, then there is nothing left for you, Madhvi, because they will be agitating their claim under the IP regime that, look, it is the violation of my copyright. Okay. But still like, your paper would have its own value if you discuss all these things. The problem with, creating an IP right, because back when I was I was at Max Planck, my supervisor, he was like, intellectual property expert, Professor Drexel, and he was against turning IP into a redistribution mechanism. You do that, but then you are going to dilute the tools. So you take a purist stance, whether it can be done, whether it cannot be done. And then you also discuss like, whether competition law can help or not. If property right is given, then intellectual property, and if Google says that, no, we are not going to use it altogether, no problem. You see, then you can continue with your story ahead. You take it further. And then finally, you say that, whether it is exploitative or not, it's up to you. I'm not going to get into it. We can revisit your paper once you are through with all these hoops. And finally comes the remedy part. Now, remedy that you suggested reminded you like an injunction. Do not use it. Now, do not use it would be, I'm not sure, like, if it's going to be like, unless you have a property right, you can't say that, right? But then again, you need to think about the innovation part. Innovation is important. And even in the Bundeskartellamt decision, surprisingly, the Bundeskartellamt back in 2015, 2016 is taking the view that, an undertaking has to a huge extent some domain over their business model, unless it is completely against the tenets of competition law. So if Google just does not use this work, this innovation would be hampered, and then I think we would be facing another trouble altogether. So what I'm trying to say here is the following. You look at the entry point that yes, Google, the AI overuse will eventually eat into the market share. Property rights are very important because unless you have the property right, you cannot come into the realm of competition law. You give some time to the case law that is developing on fair use exception, etc. Finally, you come to the competition law part. Try to solve this puzzle with what you have. Keep in mind that right to refusal to buy and refusal to supply are two different things. Continue with it, and when you design the remedy part, be very careful about it because then innovation cannot be stifled or should not be stifled, right? The balancing part has to be there in remedy. Okay, I stop here. I'll be very happy to share this paper with you that we wrote.
Thanks, Professor Kathuria. Madhavi, do you have a short response before we take questions?
Sure, I can respond to three things. Yeah. So the first, property rights and fair use. So I am closely watching what's happening with the treatment of use of publisher data, whether or not it is fair use, and that's been a bit of a mixed bucket, at least in the US. So and it's mostly been quite so the it's mostly been treated, a lot of it is being treated as fair use. However, I do not think that that damages my case. I believe, and I haven't said this in the paper, and you're right, I should probably point out why, despite this being fair use and despite publishers not having a very strong property right over publicly available data, why this is still a competition case. I think a lot of things that are legal under other regimes could be illegal under antitrust law. And so the problem here is not that Google is using something that publishers have property rights over, and that is a problem because that would be an IP problem. But that Google has this relationship which gives it monopoly power, and Google is abusing that monopoly power by imposing exploitative terms. So, and I think this occurs in a lot of other contexts. So, for example, merger review. Companies have the right to do mergers and acquisitions. However, it could still be illegal it could still be, if it is anti-competitive, a competition authority could block it. So you could have a right to do something, and yet competition authority, if it feels that you exercising that right could result in lessening of competition, it could still block it. And you could think of other examples like entering into contracts, entering into exclusive agreements. You have a right, most people have a right to enter into exclusive agreement, but that right could be curtailed in case you have a monopoly. So taking worst case scenario, even if publishers do not have a strong sense of property right over their content, and it seems that a lot of courts could be moving in that direction by treating this as fair use, I do not think that this harms the competition case. And part of the reason why I thought that this is a good case to bring is also because IP isn't working very well. Most of this is being treated as fair use, but I think that the treatment of this as fair use does not harm the competition case that can be brought, because it is separately illegal because of abuse of monopoly power lens illegal. So that's how I am thinking about it, but I'll look more into property rights and how that affects any potential competition case. The second on news media bargaining code and the sort of remedy which might be better. I agree with you. I think that having a more comprehensive code or regulation that facilitates collective bargaining for publishers would be a more comprehensive solution to the problem. But it's very difficult to actually get any regulation passed in most parts of the world, including especially, but perhaps especially in the US. So that's a utopia. It would be ideal if we could do that, but I don't have high hopes that that could happen. If we could instead have a simple competition case and a simple injunction, which could go even 60% of the way that a regulation could, I think it would still be good, because a lot of the harms, I think stopping the harm is more important than is far easier than sort of making good the harm, because a lot of harms that occur, especially in digital markets, are very difficult to make good. So I think that would be my second response, that yes, news media bargaining code is good. It has also been heavily criticized, by the way, which you might be aware of, that it only helps legacy media but not small news publishers. So it has its own problems, although I do agree that we will still have to figure out some way of collective bargaining for publishers. But I think an injunction could go a long way. And I like the lessons that I have learned in the last few years looking at all these big tech monopolization cases is that acting early is extremely important. It's very difficult to restore competition once competition is lost. So that's my second with you. And I think that I also cite the study. There was the study that was conducted which showed that most people uh, would not switch off AI overviews if they had the option to do so, which showed that does that mean that it's consumer welfare enhancing? Is it that it's a product that consumers like? What does that mean for innovation? Are we artificially clamping down on an innovative feature in search? So I think like the way that I feel this would play out if an injunction is passed is that Google would not remove AI overviews. It would just share its profits with publishers. It would have to enter into licensing deals with publishers. So I'm not like, my ask is not that you put the cat back into the bag, but that you share the profits that you get out of selling the cat. Well, that's a poor analogy, but you get the point, that it's not that Google roll back the features, but that Google share the profits that are rightly owed to publisher, because most of this is based on the use of publisher content, but that Google share its profits with publishers. Yeah, those are my three quick comments. But I'll be grateful to receive all the work that you cited, Professor Kathuria. That sounds very fascinating.
Thanks, Madhavi. We'll open it up for a few questions now. We have a little bit of time, so if anybody has questions, feel free to use the Q&A feature. Feel free to use chat. If you want to speak, please raise your hand and I'll allow you mic access and you can ask your question. So any questions immediately? Let me actually start off with my question till people sort of think about. I think at least technologically, I see AI overview as a two-phase sort of operation where you first have the Google search engine, which indexes and which extracts and which gives these things out to the public in its PageRank algorithm. And then you have the AI tool, which is Gemini, which basically collects all of this information and then summarizes it. And this is not too different from if a user clicked on a link, clicked on all the 10 links in the Google PageRank, selected it, put it in an AI tool, and you will get something similar of a summary, right? And I think I had two questions regarding this. One, I don't see, even if it's sort of and I don't know anything about competition law, but even if it's anti-competitive, isn't it more of the same, right? It's what Google does. And Google, I mean, if it's not been caught for being a monopoly until now, especially with PageRank and with extractions, why is this any different? And second, isn't the competition aspect more vis-a-vis somebody like OpenAI or Perplexity, all of which are doing similar things, but just not having PageRank and just not having the sort of dominance that Google has in search, but you can do similar things with the, let's say, the OpenAI models and go and say, okay, fine, what is X and it'll give you search results, it'll do tool use, it will give you the summary, and it'll give you summary which is pretty close to the publisher summary. And this is what I guess ANI's case is in India is against OpenAI, that you're taking away part of our market. So isn't it something, isn't the competition aspect more towards, other competitors rather than the publishers?
Yeah, no, very interesting question. I think so. So Google itself is competing against AI companies like OpenAI, etc. In say the broadly defined market for AI powered chatbots or AI powered answer engines, right? So that is right. But the story that I'm trying to tell here is that is Google as a monopoly buyer, not Google as a seller. So what you're looking at is the seller side of the market. What is the product that Google is providing, which is search plus overview or search plus chatbot. And that product, you are right, is competing with OpenAI or with Claude, etc. But that's the seller side of the market. What I'm talking about is the buyer side of the market, which is that Google is the dominant search engine, which means that all publishers must be on the search index. And so all publishers have to provide their data already to Google. That is not something that they have to do with OpenAI, which is why, so I had this graph, but I think I also cited the numbers, which is why when publishers could block AI crawlers, a lot of them ended up blocking OpenAI's crawlers, but not the same number ended up blocking very less than half of that number ended up blocking Google's AI crawlers because they were afraid they would be excluded from the search index. So the difference is about Google's power vis-a-vis publishers, not Google on the seller side and how Gemini is competing with ChatGPT. That's the seller side. That's not what we're interested in here. Here we are interested in the relationship between publishers and distributors. So you can think about the same relationship between publishers and OpenAI. I think publishers have more leveraging power vis-a-vis OpenAI because they can block OpenAI. I think this is also evidenced in the fact that OpenAI ended up entering into more licensing deals with publishers, not too many because they also started winning a lot in court on fair use doctrine, etc. But they still entered into more licensing deals with publishers once publishers installed blockers on their website. But Google just doesn't have the same constraint. So it's about Google's buyer side relationship. On your first provocative hypothetical, that isn't it the same as just a user clicking on all the organic search links and then summarizing it? I think that's going to be very different because once again, we are concerned with the buyer side relationship. What that process would end up doing is that publisher will get clicks and therefore will get ad revenue or subscription revenue, right? Every time you click on a link, that's money for the publisher. But doesn't this process make the process more inefficient for the consumer? So this is very similar to the question that Professor Kathuria asked about innovation. Are we rolling the ball back? And I think the answer to that is sure. If you think that AI overview is a good feature, it's basically just summarizing what I anyway would have taken 10 extra minutes to read. Sure, then don't roll back the ball, then share the profits. Like ask Google to enter into licensing agreements with publishers. You share the profit of what publishers have also contributed to. So that's my answers to those two great questions. Thank you.
Yeah. Thanks, Madhavi. So any questions? Yeah. So I see Siddharth has a question. Siddharth, go ahead.
Hi, Madhavi. Thank you for your presentation. I was wondering if you could maybe talk just a little bit more about like the downstream effects of like a monopsony situation to a monopoly situation where you're taking the broader view of this value chain, or maybe you have like more thoughts or more examples of or just your thoughts on one leading to the other, or some reasons to be suspicious, let's say, or vice versa for that matter. Thanks. It was really interesting.
Thank you. Yeah, that's a good question. And monopsony, actually, there's a ton of literature on monopsony and effects of monopsony. So I think I'll take two strands from that. First, I think that monopsony is actually can sometimes be a more difficult case to prove than monopoly, because monopsony, like I said, results in the imposition of less than competitive prices. So, for example, let's say you are the dominant buyer of sugarcane. You are the dominant sugar mill in an area. So, being the dominant sugar mill in the area, you can buy sugarcane at less than competitive prices. What you would ostensibly argue in that situation is that when I buy sugarcane at these lower than competitive prices, I pass on a lot of those profits to the consumer. So I end up selling the sugar at lower prices, and that's good for consumers. And so monopsony, are right that the downstream effects of monopsony can sometimes be more difficult to prove. I think similarly here, Google could argue that because Google is getting these data for free, it can now provide all these AI features for free to its users, and therefore it is consumer welfare enhancing. But there's very interesting economic literature which shows that in most of these cases, the monopolist actually does not pass on the savings to the users, at least over the long term. Over the long term, it ends up capturing most of the economic benefits itself, doesn't pass it down to consumers. I think specifically in the case of publishers, we should also remember that the consumer welfare is actually not very obvious, because the AI models hallucinate, but also there are also other consumer harms, which I discussed before, that what happens when publishers actually exit the market? Where will you get original journalistic content from? That's a consumer harm. How do we incorporate that in our calculus? Right? And AI models will also deteriorate because they'll not have any new training data to train on. So I think that when you think about downstream effects, it becomes much more complicated. But at least I know that this is the position in US antitrust law. US antitrust law says that we don't. In monopsony cases, we are concerned with the impact on the buyer market, not on the end consumers. So doctrinally speaking, what a court would look at is the anti-competitive effects on the supplier of the input, or the publishers in this case, and not on the consumers. But that's an interesting question about downstream effects. I think it's like, at least for narrative purposes, it's important to build that out as well.
Thank you.
Yeah, we're almost out of time. Does anybody have last questions that they would like to ask? Oh, I see one from Shauryavi. So please, I'll allow you mic access, Shauryavi. Please go ahead.
Am I audible?
Yes, you are. Please go ahead.
Hi, good evening. It is not directly on your paper, but you mentioned an increasing sense of disillusionment with antitrust remedies. Do you think that this phenomena looks differently across jurisdictions, or is the problem with antitrust remedies a universal failure of design in itself?
So I think, well, two answers to that. I don't think it's a failure of design. I think antitrust remedies could be very capable. The disillusionment with antitrust remedies is the failure of courts to use the entire toolkit of or the entire range of antitrust remedies that could be used. So courts have been very reluctant to use structural remedies, or to use a lot more nuanced behavioral remedies, even divestment or line of business separation, etc. So it's not a design problem. A lot of these remedies are available in most jurisdictions under antitrust law, but it's just been a general reluctance of courts to be more proactive. Courts have been reluctant to look like regulators, like they are more actively involved in regulating dynamic technology market. On the jurisdiction question, I think that this is a problem across all jurisdictions. EU probably has been more active in trying to figure out remedies, but that too it has done by introducing ex ante regulation instead of designing innovative remedies on the competition enforcement side. So you have DMA, DSA, but you don't really have too many innovative remedies in the competition cases that the European Commission has brought.
Perfect. That answers it. Thank you.
I don't see any more questions, so it just falls on me to thank both Madhavi and Professor Kathuria for joining us today. Madhavi, thank you for an excellent presentation, and Professor Kathuria, thank you for agreeing to be discussant for this Thank you all of you for joining us. This is, as I said, a monthly series, so please follow our events page, and if you please do have a look at our webpage to see and find out information about future events. Thanks, everybody, and have a good day. Thank you.
Thank you.
Thank
Thank you,
you.
Rahul. Thank you, everyone.
Thank you, Professor Kathuria. Thanks. Thanks, Rahul.